Jurisdiction of this court is provided for under Article 165, Sub-Article 3 of the Constitution. This court has jurisdiction to, among others, b. determine the question whether a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened, and d. to hear any question respecting the interpretation of the Constitution, including the determination of the question whether anything said to be done under the authority of the Constitution or of any law is inconsistent with or in contravention of the Constitution. Further, Article 23(1) provides that the High Court has jurisdiction in accordance with Article 165 to hear and determine applications for redress of a denial, violation, or infringement of or a threat to a right or fundamental freedom in the Bill of Rights. Article 165(3), as read with Article 23(1), authorizes this court to decide all matters other than those reserved for other courts, such as the Supreme Court, Employment and Labor Relations Court, and Environment and Land Court. Article 165, Article 6 also grants the court supervisory powers over subordinate courts and over any person or body exercising judicial or quasi-judicial function. The Constitution further grants the court jurisdiction to determine the issue of interpretation of the Constitution and whether anything said to have been done under the authority of the Constitution is inconsistent with the Constitution. The Constitutional authorization given to the High Court is expansive. Whether this court has jurisdiction to hear and determine this petition must therefore be viewed through the prism of Article 165, Sub-Article 3b and d, and at Sub-Article 6 as read with Article 23(1) of the Constitution. This petition alleges what the petitioner perceives to be violations of his right to fair hearing, a right in the Bill of Rights. Whether the right to a fair hearing has been violated is a matter within the jurisdiction of this court. I must add that the right to a fair hearing is guaranteed by Article 155 is one of the non-derogable rights in Article 25C. In Evans, Gidero, and others, the Supreme Court did consider the matter understated. In reference to Article 50, Sub-Article 1, define the same concept and the other time to connote a minor difference, thus fall under the list in Article 25C, which lists the right to a fair trial as a non-derogable fundamental right and a freedom that may not be limited. The petitioner also argues that the constitutional imperatives in conducting public participation were not met. This falls within the scheme of Article 165, Sub-Article 3, so that this court has jurisdiction to interrogate whether any of its processes or any of the constitutional processes said to have been conducted under the authority of the Constitution met constitutional threshold. In that respect, the issue raised in the petition centers on whether the petitioner's right to a fair hearing guaranteed by the Constitution has been violated and whether anything said to have been done under the authority of the Constitution and any law is inconsistent with or in contravention of the Constitution within the jurisdiction of this court under Article 165, Sub-Article 3b and d. Article 165, Sub-Article 6 further grants this court supervisory powers over anybody on a person or body exercise judicial or quasi-judicial function, including the National Assembly and the Senate when performing quasi-judicial functions. The first respondent has pushed an argument that this court has no jurisdiction to hear a matter arising from impeachment of the President or Deputy President on the basis of Article 165, Sub-Article 3c at office. This is a distinct process from the impeachment process in Article 145 as read with Article 150. Article 165 3c excludes jurisdiction of this court over the process undertaken in accordance with Article 144 and not Article 145 as read with Article 150 of the Constitution. Sub judice The respondents again pushed the argument that the application is sub judice in view of the application that was in petition E522 of 2024. All sides agree that in that application, the issue of conservatory orders was not pursued. This was based on the fact that the process in the National Assembly had concluded. Indeed, counsel for the petitioner read to court an excerpt of the ruling from Judge Mugambi's decision, where the counsel for the first respondent informed that court that the process in the National Assembly had been concluded. In constitutional petitions, it's quite normal for parties to come to court and within a short time, find the circumstances of their cases having changed and may only have to take other steps to bring life in those disputes. The court, having not dealt with the issue of conservatory orders in that matter, I say no more on that issue. The issue next is whether this court should grant a conservatory order. The petitioner has urged the court to grant a conservatory order and halt the process that is pending before the Senate. The petitioner's case is that the process is violative of his right to a fair hearing and that constitutional imperatives on public participation were not met. The respondents are National Assembly, supported by a third of members of that House, may move a motion to impeach the President on grounds of the Constitution or the law, where there are various serious reasons to believe that the President or Deputy President has committed a crime under international law or national law or gross misconduct. If the motion is supported by 2/3 of all members of the National Assembly, the Speaker is to inform the Speaker of the Senate within 2 days. The Speaker of the Senate is then to convene a meeting of the Senate within 7 days after receiving the notice to hear the charges. Article 145, Sub-Article 5 states that the President or Deputy President shall have the right to appear and be present before the special committee during its investigations. Where the allegations are substantiated, the Senate has, according to the President or Deputy President, an opportunity to be heard, vote on the impeachment charges. If at least 2/3 of all members of the Senate vote to uphold any impeachment charge, the President or Deputy President will cease to hold office. Article 145 lays down the procedure to be followed in